Your service is complete. I'm declaring a mistrial in this case.
Okay, welcome back to Law and Crime. We are shifting now to the very high-profile case against Karen Reed. She was on trial for the death of her boyfriend and Boston police officer John O'Keefe. The defendant and her boyfriend, as you recall, went out drinking one night. It was January 2022. So fast forward to later that night, the prosecution says that she ran her SUV into the victim, his body found outside the home of another Boston officer, Bryant Albert, at 34 Fairview. How will we forget that address? The defense alleged that she was being framed in this massive investigation cover-up where other key players had a motive to kill. So now, what could possibly be next? Well, there's a hearing coming up Monday. It's at 2 o'clock on Monday. But I want to talk about this. This is the fifth affidavit relating to one of the jurors who has said that we voted on counts 1, which was one of the murder charges, count 3, the vehicular-related murder charge, and we came to a 12-0 decision, not guilty. So the defense has brought a motion to dismiss those 2 counts. We're not sure if Monday those are going to be heard or not. It is technically some sort of housekeeping status hearing. It will not be Judge Bev, as she was lovingly known. She will not be overseeing this hearing on Monday. So the question becomes, what next? Let me read a quick passage from you from this affidavit, which I think is interesting. Again, this is now the 5th juror that has come forward through defense attorney Alan Jackson. Okay, that's the affidavit he's prepared. But he's also suggested to the court, if the court would like the basis of the affidavits executed can be done directly by the jurors, they respectfully request permission to initiate contact with jurors A, B, C, D, E, all 5 of them. Very unusual. So Sonny Slaughter is here, Tyler Bailey. Let's get into this a little bit here on so many different fronts. First of all, Tyler, what's your take on the defense position that, hey, we never got a chance to ask the judge to effectively poll the jury, not officially polling them, they can't do that prior to a verdict, but just say very simply, did you come to a unanimous decision on any of the counts? The judge didn't say that, the defense didn't make a peep at the time, but now they're saying it during this motion.
Well, with this case being so high profile, I do understand the judge's decision not to allow the defense attorneys to poll the jurors with there being a mistrial. But there's a few things with this. So you have 5 jurors right now who have issued this affidavit. And I don't think the double jeopardy thing really attaches. If these 5 jurors reach the verdict for guilty in this situation, you got to ask. Of course, the defense would not want that a conviction instated on those charges. So it seems that in the perfect world, the judge would have asked the jurors whether they did reach a unanimous verdict on some of the charges. That didn't happen here. It seems to be a mistake that is not in the defendant's favor, but she still does have an opportunity to go to trial again and have a fair trial. And that's what it's all about at the end of the day.
So you're suggesting maybe the defense was a little coy, because they don't want to push for an answer they don't want to hear, meaning, oh, what if they got, what if they were unanimous for guilt? So that's an interesting angle. Sonny, these affidavits, and remember what an affidavit is. It is a sworn statement by the person that they have personal knowledge. Well, these are just full of hearsay because they are referencing things jurors said. So I understand the defense wanting to contact jurors directly. They wouldn't normally be allowed to do that without the court's approval. But why not get the jurors back into the court, and have the judge have a little chat with them? Is that a possibility?
I think it is a possibility. With the eloquent written information that came out from the jury foreperson, I am so confused by all of these things that are happening now. I just think it's so much time has passed. Now these jurors or alleged individuals are saying things that could be complicated. I just think something should have happened but more importantly, let me say this. I think that this case was so tainted by the behavior, their actions, and the unethical conduct of law enforcement and their handling of this case. It started out convoluted. It continues to be convoluted. And I don't see where this criminal justice system is not thoroughly impacted by all that has happened in this case. We need to get things right the first time. This is just a mess, and it is dangerously a mess for everyone involved, including Karen Reed, including John O'Keefe's family.
And John O'Keefe sometimes lost in the mess that you suggest. And I was curious about your opinion there as law enforcement instructor. The Proctor factor, just exploded in this case. So Tyler, what do you think the remedy might be for this? Is an unusual motion, no doubt about it. What is the remedy you expect to see if it's handled Monday or some other day?
I don't really expect there to be a remedy. I do think this hearing will likely go forward. It has all the bells and whistles of a high stakes case that people are immediately attracted towards. And I think at the end of the day, with the times from the mistrial to now, you have 5 jurors. Who's to say that if the jurors are polled or brought in, that they're not changing their minds now? Maybe they were unanimous at one point, but then maybe they changed their opinion in that jury room. We as lawyers never get to go inside that jury room unless we're fortunate enough to be a jury. Interesting things happen in there. And it's really, they never got up there. The full person never read their verdict before Ms. Reed. And at the end of the day, there was a mistrial granted. It wasn't a perfect trial, but she'll hopefully get a day soon.
Okay, so I will ask you both this and give you a short period of time to answer. Here's my thought. This was all put together just to send a stern message to the prosecution saying, your case stinks. You have no reason to retry this case when the top 2 charges clearly were not an issue for this jury. Good luck finding another jury. So, Tyler, what do you think about that? This is the message is the motion. It's not really intended to get a dismissal.
Yeah, well, the message, you see that her defense team is fighting everything tooth and nail. They're going to cross every T, they're going to dot every I, and they're going to highlight why the prosecution does not need to retry this case. I don't think they need to retry this case. Okay,
Sonny, give me your 15-second decision. Is this a motion just to send a message?
Yes, I think this is a motion to send a message, not to retry the case.
Okay, we're going to find out. Again, the hearing is coming up on Monday at 2 o'clock. We'll see if they even wade into this mess or put it off for another time. Hey, I've got to thank and excuse Sonny Slaughter, Tyler Bailey. Always a pleasure to have you guys. I appreciate it. We'll see you next time here on the network, and we are still in verdict watch, so keep that in mind. The Daisy jury is busy. I'm Michael Bryant. I'm out of here. Imran Ansari is up next. Try to do the right thing. See you next time on Law and Crime.